everyone, I'm Heather Scott. I'm a partner at Gill Jennings Every. I'm a UK and European patent attorney. And today we're going to be doing a basic introduction to intellectual property. So, what is intellectual property? What do we actually mean by that term? It's a phrase that gets bandied about a lot, and I often see it misused in the media. So it's worth taking a moment to consider what it really means. There are many different definitions floating about out there, but in my words, IP is anything created by the mind once turned into something real. So in other words, it's the product of somebody's thoughts combined with their efforts in bringing those thoughts to life, which results in intellectual property. So just as some examples, a very vague idea for a novel, that's not intellectual property, but once it's actually written and composed, the text of the novel is. Another example, the concept of a vehicle that flies is not intellectual property, but the knowledge about how to actually make that happen, so the blueprint for an aeroplane, for example, that is. So what really distinguishes IP from other types of property is that it is intangible. And what I mean by that is that you can't touch it, you can't hold it, you can't pin it down physically, and you certainly can't lock it in a cage, unlike other types of property. But just like all other types of property, it has value. It has value for its creator, and that's why it needs to be protected. And that's what we're really here to look at today. So I think the concept of intellectual property is best illustrated with some examples. So here are some common types of IP. This is by no means a complete list. Over here on the left, we have things like photographs and text and website layouts, drawings, and so on. These all hold intrinsic value to their creators because you can sell items which embody them, like books and sound recordings. Then we have things such as technical innovations, which lead to new products and new processes. And these can give one company the edge over another company because it results, for example, in a better functioning product, which consumers are more likely to want to buy. Or, for example, a method of manufacture might reduce the cost of manufacture, and that can drive up profits. Also very valuable to a company are things which convey its brands. So, for example, the company name itself, product names, and also logos, as well as slogans and taglines. As we all know, a desirable brand clearly attracts buyers. And then we have the appearance of the product itself. So, for example, its shape or look, or maybe the way it's decorated, its ornamentation. And it's also worth bearing in mind that nowadays, not all products are three-dimensional. Some of them are two-dimensional, like, for example, typefaces or fonts. As you'll notice, I've grouped these into 4 areas. So I would say these are the main categories of IP. We have creative works, so the photographs, music, drawings, and written works. Then there's IP related to technology, including new products and new processes. Then we have things which convey branding. So these are names and logos and so on. And finally, aspects of appearance. So what the product actually looks like, maybe its shape or its decoration. So IP as a whole includes some wildly different things. But as I've already emphasized, one thing that's in common with all of them is that they hold value. They are valuable to their creators. And intellectual property rights exist to protect that value. And they do that by enabling the owner to assert their ownership of the IP in question and to prevent it being appropriated by anyone else. However, this huge variation in different types of IP means that the same type of protection is not suitable for all of them. For example, if somebody could protect their technical innovation forever, then that would stifle innovation and competition because nobody else could ever make the same type of product. On the other hand, that's just not true in the case of a brand, because there, other people can compete. They can make the same type of product. They just have to use their own name. So in order to account for this, we have different types of intellectual property rights which exist for different types of intellectual property. So for creative works, we use copyright. For IP relating to new technology, this is protected using patents. For branding, it's trademarks. And for aspects of appearance, they can be protected using designs. So in summary, even if you have just one product, there may be many different types of intellectual property which exist in the product. Here I've got an example of a running shoe by the well-known company Nike. Just to illustrate the point, they can protect the appearance of the shoe or parts of it using designs. The well-known swoosh logo and the name Nike, they'll be protected using trademarks. And if there's an invention in here, for example, it might have a new type of cushioned sole which helps to prevent running injuries, then that can be protected using patents. So it's important to see how the different types of IP and corresponding IP rights work together to protect all the different aspects of a product. If you'd like to find out more information, you can visit our website, which is www.gje.com, or feel free to email me, Heather Scott, at gje.com, or connect with me on LinkedIn. Thank you very much.